All right, let's dive in. We're looking at how those dissenting opinions in the Supreme Court, the ones that don't become law right away, can still kind of influence legal thinking down the line.
They really can.
We've got these two cases, Katz v. United States and Olmstead v. United States, both about wiretapping and the Fourth Amendment.
Right.
They show how much weight those dissenting voices can actually have.
Yeah, it's interesting, isn't it? It's almost like planting a seed,
Oh, okay.
It might not sprout up right away,
Right.
but there's definitely potential there for it to grow into something.
I like that.
Dissenting opinions, they offer a different way of looking at the law, and while they might not win the case right then and there,
Yeah.
they can definitely spark debate, make people think, and even influence how courts handle similar cases later on.
So it's not just like, bang, the gavel goes down and that's it. It's
Yeah.
more like setting the stage for future legal arguments.
You got it, exactly. So let's go back in time a bit to 1928 and the Olmstead case. It might surprise you, but the Supreme Court actually ruled in favor of wiretapping without a warrant back then.
No way. Really? That's crazy. I mean, by today's standards, that's just wow.
Yeah, it is kind of wild when you think about it.
Yeah.
So in this case, federal agents were wiretapping Roy Olmstead's phone conversations without a warrant. But here's the thing. Back then, people mostly thought of the Fourth Amendment as protecting physical spaces.
So their homes.
Exactly. So since the agents didn't actually enter Olmstead's home, the court decided it wasn't a violation.
So basically they thought your walls protect your privacy, but your conversations don't. I guess smartphones and the internet were beyond their imagination.
You're telling me. But one justice had a completely different take on it, Justice Louis Brandeis.
Oh, okay.
He wrote this powerful dissenting opinion where he argued that the Fourth Amendment should protect the right to just be left alone, no matter if someone physically trespassed or not.
That's, thinking way ahead, especially for that time. What made his argument so strong?
Well, Brandeis argued that new technology, like wiretapping, could violate someone's privacy just as much as a physical search, even if you don't set foot in their house. He even wrote this famous line, "The protection of the right to privacy is the most important feature of the Fourth Amendment."
Powerful stuff.
Oh, yeah. He basically predicted how technology could threaten privacy in the future.
So even though Olmstead lost the case, Brandeis's dissent made people question how we should think about privacy, especially as the world changes, right?
Absolutely.
Yeah.
His words really stuck with people, and you could say they laid the groundwork for how legal thinking about privacy would change later on. It's like that seed we talked about starting to sprout.
I'm really curious about this Katz case from 1967 now. Is this where Brandeis's ideas finally blossomed?
Let's see. The Katz v. United States case was about this guy named Charles Katz, who was convicted based on evidence they got from wiretapping a public phone booth he used.
A phone booth?
Yeah, and he argued that this violated his Fourth Amendment rights, even though the booth wasn't his private property.
So this time, it wasn't about someone barging into your home. It was about whether you could expect privacy even in a public phone booth.
Exactly. Could you reasonably expect privacy there? That was the question. And guess what?
What?
The Supreme Court actually agreed with Katz.
They did. Wow. So they overturned Olmstead.
They did. It was a huge turning point.
So what changed their minds? Did they suddenly get a glimpse into the future of technology?
Not exactly. But Brandeis's dissenting opinion from Olmstead, it played a huge role. The court used his reasonable expectation of privacy test and said the Fourth Amendment protects people, not just places. They said even in a public space, you have a right to privacy if it's reasonable to expect it there.
So that's a big shift. It's not just about whether cops break into your house. It's about whether they violate your privacy in a way that any reasonable person would think is wrong, right?
Right. And this idea, this shift in thinking, it's had a massive impact on privacy law, especially in the digital age.
Wow, it's amazing to think Brandeis, writing all those years before, almost predicted this. So how exactly did this Katz decision and the reasonable expectation of privacy test change privacy law as we know it?
Well, that's a big question. Maybe we should save that for the next part of our deep dive.
Yeah, you're right.
All right.
Okay, deep divers, stick with us. We'll be back in a flash to explore how the Katz decision and the reasonable expectation of privacy test have shaped the legal landscape, especially in today's digital world.
It's a fascinating story.
And we're back. Before the break, we were digging into that Katz v. United States case and how it really turned things upside down for privacy law. So how does this reasonable expectation of privacy test actually play out in real-life situations?
Well, it's become a really important part of Fourth Amendment law. used to figure out all kinds of privacy issues, especially in our digital world.
So it wasn't just about phone booths back in the 60s. It's actually being used to interpret privacy in our tech-driven world today.
Absolutely. It's not just some relic of the past.
What?
For example, let's look at GPS tracking.
Okay.
In 2012, the Supreme Court heard this case, United States v. Jones. The government had put a GPS tracker on a suspect's car without getting a warrant.
That seems like a pretty clear invasion of privacy, right? I mean, come on.
You'd think so, wouldn't you? And the court agreed. They said it was a violation of the Fourth Amendment because people have a reasonable expectation of privacy when it comes to their movements. You can't just track people everywhere they go without a good reason.
Makes sense to me. So Big Brother can't just be following our every move.
Not without a good reason and a warrant. And this case shows how that reasonable expectation of privacy test can be applied to new technologies, even stuff that didn't exist back when Katz was decided. It's not just about protecting your home anymore.
Right. But there have to be limits, right? I mean, there must be times when someone wouldn't have a reasonable expectation of privacy.
Yeah, you're right. It's not like this total shield.
Yeah.
It all depends on the situation. Courts have to look at the specific details of each case.
So how do they decide? What kinds of things do they consider?
Well, first they ask if the information or the activity is something that society generally thinks of as private. Like sharing a secret with a friend is different from posting it online for everyone to see.
Of course, that's a big difference. What else?
They also look at whether the person tried to keep things private.
Like using a password on your phone or setting your social media to private?
Exactly. Taking steps to protect your info makes a difference. And naturally, where the information or activity happened is important too. Remember, Katz showed us that even a public phone booth can offer a reasonable expectation of privacy, depending on what's going on.
So it's not just about being in public or private, it's a lot more complicated.
Much more nuanced. The reasonable expectation of privacy test is kind of a flexible tool that courts can use to figure out privacy in a world where technology is always changing. We've talked a lot about the legal ins and outs, but what about the bigger picture? What does all this say about dissenting opinions in a democracy?
Yeah, good point.
It shows how important it is to have checks and balances, even in the highest court. Dissenting opinions can push back against the majority, point out problems, and offer different ways of looking at things. They make sure that different viewpoints get heard and that the law can keep up with changes in society.
So it's not just about who wins or loses a case, it's about making people think and allowing for different interpretations of the law, like a healthy debate.
Exactly. And those dissenting opinions can plant seeds for change, just like we saw with Brandeis and Olmsted. They introduce ideas that might be controversial at first, but could eventually become the norm.
It's really wild to see how one voice, one dissenting opinion, can have such a huge impact.
It really is. And it shows us that the law isn't set in stone. It's always evolving, shaped by new ideas and different viewpoints.
Okay, deep divers, time for another quick pause. Don't go anywhere. We'll be back to wrap up this deep dive and talk about the lasting impact of dissenting opinions and what they mean for privacy in this increasingly digital world. We're back for the final part of our deep dive, and man, what a journey it's been. We've been talking about dissenting opinions, how they can shake things up, and their impact on the law over time. And you know what?
What's that?
It's incredible how Justice Brandeis's idea of a right to be let alone from all the way back then is even more relevant today than ever.
It really is.
Yeah.
Makes you wonder what Brandeis would say about facial recognition technology, data breaches, algorithms that seem to know you better than you know yourself.
I know, right? Does the reasonable expectation of privacy test even hold up anymore when we share so much of our lives online? I mean, we're basically giving up bits of our privacy all the time without even thinking about it.
It's a tough question. Legal scholars and privacy advocates are wrestling with that all the time. This whole digital age has really pushed the boundaries of what's considered private and what we're okay with sharing.
So is the Katz standard, outdated now? Can we even expect privacy in a world where our data is constantly being collected and analyzed?
That's the big question. Some experts think we need entirely new laws, specific to this digital age. Laws that address things like data collection, online surveillance, how algorithms are used, all that.
It's like uncharted territory, almost. Tech is moving so fast, the law can barely keep up.
And that's where those dissenting opinions come in. They offer a different perspective, challenge the way we think, and can help us figure out these tough issues. It's about finding ways to keep us safe and protect our rights.
So it's not just about following what's been done before. It's about using those dissenting voices to open up the conversation, finding new ways to understand the law as the world changes.
Absolutely. The Katz case and Brandeis's dissent, they teach us that this fight for privacy, it never really ends. We have to stay alert, think critically, and be willing to challenge the way things are.
It's pretty inspiring, honestly. Even with all this crazy technological change, one person's voice can still make a difference.
It really can. And it reminds us that we all have a part to play in shaping how privacy looks in the future.
Well, deep divers, our time is up, but wow, what a deep dive it's been. We've seen how dissenting opinions can spark change, shake things up, and really shape the legal world. It shows us that the law is alive, it's dynamic, always changing.
And who knows, maybe you'll be the one to start the next legal revolution.
So keep those minds curious, everyone. Pay attention to those dissenting voices. You never know what they might inspire. We'll see you on our next deep dive.